Hello, everyone, and welcome to One Civil Law. For today's story, we turn our attention to none other than Jussie Smollett, or Juicy, as his friends know him. As you will recall, Juicy himself perpetrated a hate crime onto himself and then almost started a race war. He purported that he went out at like 3 a.m. during a polar vortex in Chicago for the purpose of getting Subway and was attacked by two white guys. The evidence would later demonstrate that he did it to himself, hiring the people themselves, and they weren't so much white as they were very black. they were very much the opposite of white. But he perpetrated a hate crime on himself. He said that these white men shouted, "This is MAGA country," as they poured bleach on him and put a noose around his neck. And as Dave Chappelle noted, none of these details added up at all. None of these details added up at all. So he was convicted on falsifying a police report times, I think, 15. And he was sentenced to, 6 months? But he only actually did something like 4 days in jail before he was bonded out pending his appeal. Well, his appeal, having been denied by the Court of Appeals, has been granted by the Supreme Court of the state of Illinois on the basis of detrimental reliance, is the fundamental theory here. Having relied on a representation by the state to his detriment, he gets the benefit of that. So for our lawyer friends in the audience, this sounds a lot like promissory estoppel or collateral estoppel principles. Or you can just go on straight contract principles, basically. Having bargained for exchange, I pay a fine inducing community service, you make the case go away. So we can either do this based on contract principles, we can do it on promissory estoppel, we can do it on collateral estoppel. And this sounds very similar to what happened to Cosby as well, because Cosby was basically kind of similar in some ways. They got him to give testimony against himself in a promise not to use it, and then used it against him. Which, at that point, it was more like, it's just kind of the same principles, like bargain for exchange, The only reason I made the statements was the promise you wouldn't use against me, queen for a day kind of thing. And then you used it against me, and then you convicted me on that basis. And the Supreme Court of Pennsylvania, as you might recall in that case, 7-0 said that was improper. Now, there was a split in the Pennsylvania Supreme Court because 4 of the justices thought, this case should just go away because it was so prejudicial. And 3 of them thought the case could be brought back, but without the tainted evidence. So there was a split as to the remedy. All of them agreed it was bad, but there was a division of opinion when it came to Cosby what to do about it. But of course, 4 members being enough, 4 members said, this was so prejudicial that the case should just go away. But it has some very strong parallels, the same kind of idea. Cosby made statements in detriment to his reliance. The state broke its representation. And in the same kind of way, Smollett made a agreement to pay a fine and to do community service in representation. The case would be dismissed. And so that's basically the theory of the case. And so that kind of makes sense, even if I am grossly disappointed, because Jussie Smollett is a horrible, horrible man who perpetrated a hate crime and should probably be in federal prison for conspiracy to commit hate crimes against himself. But I digress. Incidentally, not for nothing, the federal government could hypothetically bring a case. I believe it's still within the statute of limitations. And they would not be bound by the same problem because of separate sovereigns. So if Trump wants to really do a solid, I'm just saying, this would be a potential avenue. But we turn our attention to what the state of Illinois has to say on the issue for the moment. In a decision that came down this morning, Justice Rochford delivers the opinion of the court, into which all the other justices concur in the opinion. The Chief Justice and a Justice Cunningham takes no part in the decision. So unanimous with some recusals. Okay. The Supreme Court of Illinois writes thusly: today we resolve a question about the state's responsibility to honor agreements it makes with defendants. Specifically, we address whether a dismissal of a case by nolle prosequi. I can never pronounce it properly. I'm not sure I've ever heard it really pronounced that many times. I just say nolle pros, and so does everyone else. Anyways, in by nolle pros, which is we decline to prosecute, allows the state to bring a second prosecution when the dismissal was entered as part of an agreement with the defendant and the defendant has performed his part of the bargain. We hold the second prosecution under these circumstances is a due process violation and therefore reverse. Not exactly double jeopardy, but rather due process. Okay. A complete statement of the facts may be found in the appellate court's opinion, who told Jussie to stuff it. The appellate court wasn't buying any of this, but the Supreme Court has different thoughts. We set forth here only those facts necessary for the understanding of the sole issue we decide. On March the 8th of 2019, a grand jury returned a 16-count indictment charging the defendant, Mr. Jussie himself, Juicy, the Juice, with felony disorderly conduct. The charges allege the defendant falsely reported to the Chicago police officers he'd been the victim of a hate crime. In other words, falsely reporting to the police. That was the felony times like 16. Making false statements to the police times 16. 18 days later, on March the 26th of 2019, it might be outside the statute of limitations for the feds. Damn it. Oh well, anyways, pressing on. An assistant state attorney explained to open court before Judge Stephen Walkins that the state was moving to nolle pros the charges, which is just, they're dismissed. The assistant state attorney explained the decision to the court as follows. So here's what the state attorney sent the time. Judge, on today's date, the state does have a motion in the case. After reviewing the facts and circumstances of the case, including Mr. Smollett's volunteer service, and the term volunteer here is somewhat misleading because it wasn't really volunteer now, was it? In the community, an agreement to forfeit his bond to the city of Chicago, the state's motion in regards to the indictment is to nolle pros. We believe the outcome to be a just disposition and appropriate resolution. I do have an order directing the clerk of the circuit court to release bond payable to the city of Chicago to be sent directly to the city of Chicago, Department of Law, and there's an address and person there who will take care of that on behalf of the city. The trial court granted the motion to nolle pros and released the defendant's bond to the city of Chicago, which I think was $10,000. So it wasn't a lot of money. Not as much as he cost the city of Chicago, incidentally, in time, energy, resources, plus, basically started a race war. On April the 5th of 2019, the retired appellate justice filed a pro se motion to appoint a special prosecutor in the matter of People of the State of Illinois versus Jussie, which was pretty bizarre on a whole number of levels. I didn't know you could do that. Apparently in Illinois you can. A retired appellate justice files a pro se motion, so he's basically filing a motion to intervene in a criminal case as a pro se. And apparently that is an option in Illinois. Who knew? Who knew? The motion raised questions about the resolution of the charges and the matter in which the Cook County State Attorney, Kim Fox, had recused herself. And we use the term recused very lightly because she didn't really recuse herself. She didn't recuse her office. So, yeah. After briefing an argument, Judge Michael Tuman entered an order granting the appointment of a special prosecutor. So the pro se motion from a member of the public was apparently successful somehow. Okay. In the order, Judge Tuman reviewed the facts of the case and wrote that the disposition of the case by way of the nolle pros had shocked officialdom as well as the community. Fair. Judge Tuman noted that both then Mayor Rahm Emanuel and then President Donald Trump, soon to be president once again, had issued statements condemning the resolution of the case. Judge Tuman specifically found that negotiations on the disposition had dated back to February 26 of 2019, when First Assistant State Attorney Joseph Maggots wrote the Cook County State Attorney's Office, could offer diversion and restitution, but he would indict if something could not be worked out. On February 28th of 2019, the chief of the criminal division told detectives that they could no longer investigate the crime, and they felt the case would be settled with the defendant paying $10,000 in restitution. That would be the bond I just referred to earlier, as well as the community service. So please give us the $10,000 bond, which nowhere comes close to paying the cost of the city of Chicago. Whether or not they can sue, I'm not sure, but yeah. Judge, I think they did try to file a lawsuit, incidentally. I don't remember how that panned out, but for the moment, we'll stick to the criminal charges. Judge Tuman then addressed at length the circumstances surrounding Fox's recusal. Judge Tuman found out that once Fox recused herself, appointment of a special prosecutor would be required, because that is normally how it works. Fox is the prosecutor. She's the elected head of the office. Okay? And because all the people that work from her are her agents, because they all report to her, all their power is her power, and vice versa. Like, they have no power but the power she gives them. They have no power but the power she gives them. And if she's recused, then she can't do anything, including giving them power, because she's recused. Normally, that's how that works. Normally, recusal means recusal of you and anyone below you. And because you're the head of the office, that would mean the whole office. So normally, we'd have to go get a special prosecutor. And different states have different procedures for that. Not the first time that this has happened. So there's a procedure for it. She didn't follow it. Instead, Fox appointed her first assistant, Joseph Maggots, which again, how? How did she appoint him? Because she's recused. If she's recused, she has no power. So how can she make an appointment? But she tried anyway, and she made the appointment to an entity that did not exist because there's no legal cognizable office of the acting state attorney. Right, different states have different procedures for this. This might be a valid procedure in some state, but not Illinois, it's not. Judge Tuman wrote in People v. Ward, the court held that if the case is not prosecuted by the attorney properly acting as an assistant state attorney, the prosecution is void, and the cause should be remanded for prosecution by a proper prosecutor, which kind of makes sense, right? Void ab initio, void from the beginning. There is no power here. There is no power here. It is void. Okay, yeah. Judge Tuman also cited cases where proceedings have both been voided because of prosecution by unlicensed attorneys. So that's happened before too. Judge Tuman concluded that there's no duly elected state attorney of Cook County when the defendant was arrested, charged, indicted, or arraigned because there was no state attorney in the courtroom when the no pros was entered. So basically they're saying the prosecution side isn't really there. There's some people who are cosplaying as the state attorney, but they're not really the state attorney, and so they don't have power. Accordingly, Judge Tuman determined that the appointment of the special prosecutor was mandated to conduct an independent investigations of the actions of any person or office involved in this case and determine whether or not there be further grounds to prosecute. Judge Tuman later appointed Dan Webb as special prosecutor, which apparently is a thing the judge can do, which makes sense. Different states have different procedures for that, and that apparently is one of the procedures that's available. Cool. Following the Office of the Special Prosecution investigation, a special grand jury, and by special, we simply mean that it was called for this particular purpose, as opposed to a general grand jury, which sits for a time, usually several months. And here's a whole bunch of cases. Is a general grand jury. A special grand jury is one that we got together just for this thing. Okay, the special grand jury indicted the defendant on 6 counts of the disorderly conduct. So from the 16 becomes 6. Fine. In the information release, which is part of the record, the police explained that reasonable grounds existed, or the special prosecutor rather, explained that reasonable grounds existed to further prosecute because he had planned and participate in a staged hate crime attack and thereafter made numerous false statements to Chicago police. Jussie Smollett did many, many bad things. He did many, many bad things, and he's a horrible, horrible person. In the information release, the special prosecutor also stated that it determined that further prosecution of the defendant was in the interest of justice for several reasons. First, the special prosecutor relied on the extensive nature of the false police reports, and the resources contended that the office disposition of the case was not similar to how it disposed of similar cases. In other words, the state's attorney's office dealt with this in a way they don't normally deal with cases. It's like they were giving it some kind of special treatment. Oh no. Special treatment and corruption in my Chicago? It's more likely than you think. The special prosecutor sought documentary evidence that would back up the claim. And the state's attorney's office was unable to provide it. Hey, state's attorney's office, we think that you are doing some shit. Do you have anything that proves that you didn't? Do you have anything that proves that this is normal? No, you don't? Oh, amazing. The special prosecutor disagreed with how the state's attorney resolved the case. The special prosecutor stated that it had obtained evidence showing that it believed the state attorney, which is to say Kim Foxx, believed the case was strong at the time it obtained the indictment. However, just 3 weeks later, the state's attorney decided to resolve the charges under the following circumstances. So they believed it was a pretty strong case because, it was. But 3 weeks later, magically, they're less convinced. And here's what the state attorney, Kim Foxx, wanted to dismiss under these conditions. 1, complete dismissal of the 16-count felony indictment. 2, the only punishment, and we're using that term very loosely, for Mr. Smollett was performance of 15 hours of community service. I'd like to take note that's less than 1 hour per felony, which is one hell of a deal. I'm just saying. Less than 1 hour of community service per felony. That's one hell of a deal, man. I think there's a lot of felons who'd be very, very interested in a plea under those kinds of circumstances, Ms. Fox. Just saying, wow. Requiring Mr. Smollett to forfeit his $10,000 bond, and we're going to use the term restitution, although normally restitution restores. That's sort of in the nature of restitution, to restore. And the city of Chicago went through a bit more than $10,000 worth of expenses relating to this. So we're using the term restore somewhat loosely. As the court, or as the state attorney noted at the time, less than 10% of the $130,000 in police overtime, and really, realistically, you can do another 10 times on that when you're figuring out the entire cost. So $130,000 in overtime, realistically more like $1.3 million, at least in real expenses. But, we'll say it's $130,000. Not requiring that Mr. Smollett admit any guilt of his wrongdoing, which again is pretty generous. He's not required to admit any fault. That's amazing. In fact, following court proceedings on March 26, Mr. Smollett publicly stated he's completely innocent, and he has stated that, and he will continue to state that until the end of time. I am innocent. Also, he's not suicidal. He'd like to let you know. Also, not requiring that Smollett participate in the deferred prosecution program, which he's eligible to participate in, and require a 1-year period of court oversight. So, as many jurisdictions do, there are deferred programs available, which, there are like things in place for allowing people to potentially get out of charges, with an eye towards dismissal. But there are programs in place for that, and he didn't have to do any of those things. He got special programs just for him. How nice. How nice. For no corrupt reasons, I'm sure. For absolutely no corrupt reasons, I'm sure. The reason the state attorney had to create a whole new program just for him was in the interest of justice. None of our other programs were really sufficient. So we had to create something sui generis out of due process. That's how good a prosecutor's office we are. We're willing to create something just for you because due process requires it. No corrupt reasons, I'm sure. Fun and exciting. Fourth, the state attorney, that is to say Kim Foxx, had been unable to identify any new evidence they learned of between indictment and dismissal that changed their view of the strength of the case. So it's not like some evidence somehow came from on high and be like, oh my God, we didn't realize this thing. 3 weeks ago, we thought this was a slam dunk, and this mystery evidence somehow came that somehow radically changes our view, which, by the way, is not something that's like unknown to lawyers or unknown to law. It happens. It happens with a fair amount of frequency. I'm not sure I exactly call it common, but it happens where something happens, where some information comes that radically changes your perception of the case, right? It can happen, but it's not like that did happen. It's not like somehow the fates have gifted us this information like, oh my God, our case is so weak. What were we thinking? No, that isn't what happened. It's no corrupt reasons, though. Defendant moved to dismiss the indictment on double jeopardy grounds. He also moved to dismiss the basis of the appointment of special prosecutor was invalid. The trial court denied the motions. Defendant later hired new counsel who moved to dismiss the indictment on the basis of the agreement that he had reached with the special attorney, Kim Fox, or the state attorney, Kim Fox. Defendant argued that he had entered into a non-prosecution agreement with the state attorney, and the agreement was executed and enforced, which incidentally is an agreement without it being reduced to writing in any way, which again, you really want to do this in writing. Also, just like for Jussie's own sake, this should be in writing. This also incidentally was a point of critique I had when it came to Cosby's lawyers at the time, because Cosby's lawyers also failed to get their agreement in writing. Does Cosby not have the ability to get good lawyers? Like where they say, hey, Cosby, we really like you to make this incredibly incriminating statement, but we won't use it against you. And their lawyers are like, cool, would you mind, writing us a memo saying that? That might be nice to start with. But neither Cosby's lawyers nor Smollett's lawyers thought, a napkin, something scrawled on a napkin from a bar might be helpful. That's just like, the oral representation is enough. Who are these lawyers, man? Get it in writing, damn. Anyways, he further argued that the office of the special prosecutor was bound by the agreement because the special prosecutor and the state attorney are both agents of the state, which, fair enough as far as that goes. Fair enough as far as that goes, right? Assuming that there is an agreement, then it would be binding on the state because it is the state versus Smollett. So assuming there is an agreement, then yes, then anyone who is now taking on the mantle would be bound by it because, which also incidentally also happened in Cosby, because the prosecutor who made the deal with Cosby wasn't the same prosecutor who wound up prosecuting him. It was a different prosecutor. There was an election that happened, and there was a new exciting prosecutor. And the new exciting prosecutor was like, I don't really like what my predecessor did. Well, a little bit tough shit, because your predecessor was, acting on behalf of the government. And, there's that problem. So, yeah. So far, it's fair enough as far as it goes. Defendant performed his part of the agreement when he forfeited his monetary bond, the $10,000, and satisfied, which also, by the way, is less than $1,000 per felony, as long as we're critiquing. It's $660 per felony. Man, where do I get these indulgences at? Where do I pay my $660 for my felony hall pass? That's what I want to know right now. What government agency do I have to go to? Who do I have to write a check to for $660 so I can get my felony hall pass? Asking for a friend. Asking for a friend. Defendant cited People v. Starks for the proposition that agreements between prosecutors and the defense will be enforced, and if defendant performs his end of the bargain, then the state must fulfill its part, which, basic contract principle 101, right? Basic contract principle 101. We have an agreement. I've performed. You must perform. Defendant further contends the public policy supports enforcing the agreement between prosecution and defense. Defendant asserts that he had been duped by the state. Jussie, I don't think you could argue that you've been duped. Man, that look in the mirror, my friend, on that one. Look in the mirror. I've been hoodwinked. Who sang this again? Damn. Defendant asserted that he'd been duped by the state because it re-indicted him after he had forfeited a substantial bond in exchange for 15 felonies. I do not think $10,000 is substantial. I'm not really in a mood to write a $10,000 check. It's not something I could readily afford. But if the alternative is 16 felony charges, I will write that check. Substantial bond. In exchange for getting the charges dismissed, the trial court heard oral argument on the motion. During oral argument, counsel for defense argued that what happened here was more egregious than in other Illinois cases where the prosecution reneged on a deal. Here, the deal had already been enforced, and the special prosecutor was attempting to resurrect something that had already been decided. The trial court denied the motion. The court stated that Judge Tuman had found there really was no state attorney running the show at the time because of the confusion, we'll call it confusion, caused by the recusal announcement that was publicly made. I think a better word for confusion would be corruption, but they both start with C. So I guess close enough. Accordingly, the court stated that it was not going to challenge Judge Tuman's order or his reasoning, and it could not find a way to grant pretrial relief. Fine. Following the jury trial, defendant was found guilty of 5 counts of felony disorderly conduct. The trial court sentenced him to 30 months probation, with the first 150 days to be served in the Cook County Jail. The court also ordered him to pay a $25,000 fine and $120,106 in restitution to the city of Chicago, which, by the way, still isn't enough, but I digress. Defendant appeals, raising 13 issues. The appellate court described his appeal as challenging virtually every aspect of the second prosecution that resulted in his conviction and sentence. The appellate court rejected all of his arguments and affirmed the conviction and sentence. Relevant to his argument that the second prosecution was barred because he had entered into a non-prosecution agreement with Kim Fox, the appellate court majority held that the second prosecution was not barred because the first case was disposed of with nolle pros. Jeopardy did not attach. Jeopardy attaches in a bench trial once the first witness is sworn, and attaches in a jury trial once the jury is sworn. That's when jeopardy attaches. It was nolle pros. There was no jury. There is no double jeopardy. There was never jeopardy in the first place. So yeah, double jeopardy doesn't quite make sense. And the state Supreme Court doesn't even say double jeopardy. They say due process. They're going to make a slightly different argument. Okay. The majority stated it is well established that Illinois law provides that a nolle pros is not final and will not bar a second prosecution. That is the standard rule. The majority acknowledged in dissent's argument that the state's right to re-indict after a nolle pros can be bargained away when making a bilateral agreement. However, the court has stated that no Illinois court has ever applied the principle of contract law in applying the scope of a nolle pros disposition. So, a nolle pros is not a contract. That's basically what they're saying. A nolle pros is not a contract. And what is or is not a contract is ultimately a matter of state law. Contract law is determined by state law. So is it a contract or is it not a contract? Well, the appellate court says no, and they say we can't find any case that says it is. So it's not a contract. Okay. I mean, fair enough. The majority considered several cases where agreements between defendants and prosecutors were enforced, but determined that they were all distinguishable. And I think they were. I can't remember what any of those cases are off the top of my head, but I thought they were all distinguishable too. Which, fair enough. Just because they're distinguishable doesn't mean that this isn't a new thing unto itself. It just means it's different than everything that happened before, which it kind of was. This was corrupt. Again, corruption in my Chicago? Who knew? Who knew? $12.50 on a squat machine? Damn, man. That's pretty impressive. Kick ass. That's better than my PR. My PR is like 740 for reps. 3 times 10. You did 1250, 12 by 4? Holy shit. Okay, yeah, your leg press is better than my leg press. Keep carrying on. Turning back to the case. The court here considered that the record was silent regarding any non-prosecution agreement between the state attorney and Smollett, and the only disposition requested by the state attorney was nolle pros, which does not impart finality. Fair enough. Justice Lyle dissented. Justice Lyle would have found the second prosecution barred by the agreement that the defendant reached with the prosecutors. This is referring to the Court of Appeals. Justice Lyle agreed with the majority that a second prosecution is not barred when the state enters a unilateral nolle pros. However, Justice Lyle cites State v. Kelberg, coming from Connecticut, by the way, so we're citing law from a foreign jurisdiction, which, fair enough, but is still persuasive authority. Argued that the report from the special prosecutor filed with the trial court detailing the findings of his investigation showed the state attorney had entered into an agreement with defendant. Nice. The report also explained the statement that the assistant state attorney read in court when the charges were dismissed was drafted in conjunction with the defendant's attorney. Justice Lyle pointed out that the assistant state attorney's use of the word disposition and resolution when entering into the nolle showed that it intended finality. Okay, but it still requires them to actually, show up and be there. Justice Lyle argued the majority's contention that the nolle did not bar further prosecution was unsupported legally and factually. Justice Lyle cited Illinois case law establishing contract law principles apply in pre-charging phases. Justice Lyle discussed Kelberg at length. She found persuasive the Connecticut Supreme Court's discussion of a nolle pros that are entered into a unilateral act by the prosecutor versus those that are entered as part of a bilateral agreement. So the Court of Appeals judge is looking at the distinction between a unilateral nolle pros and one that is bargained for, even though Illinois apparently has never looked at it as a bargain for exchange. But the Court of Appeals judge says, well, there's this case from Connecticut that makes this distinction, and I think we should too as a matter of our law. Which, fair enough. That's kind of how judges reason. They just didn't get the majority at that time. In a later situation, re-prosecution is barred after nolle if defendant had performed its obligation under the agreement. Justice Lyle would have applied those principles here. Because the defendant gave up something of value in exchange for resolution of the original case, he could not be prosecuted. Justice Lyle, then writing in the Court of Appeals in dissent, wrote the following. While that result may appear to be unjust to some, another trial court judge unrelated to the proceedings cannot unilaterally renege on a deal and grant the authority to the special prosecutor to violate the deal that bound the state. So this is all based on the premise that there is a deal and that it should be understood by basically contract law principles, because what is a deal if not a contract, right? That does not just violate contract law, so they're explicitly saying that, but would be manifestly unjust and would make every agreement the state enters into with the defendant tenuous, leaving defendants wondering whether public outcry will destroy careful negotiations with the state. Public policy considerations and reverence for our justice system disfavor reneging on such agreements and should never be outweighed by the cacophony of criticism as to the terms of the agreement. Badass language. I appreciate that. Cacophony. The cacophony of public outrage. I like the way you write. It makes me happy. we allowed defendants petition for leave to appeal. So having lost at the Court of Appeals, they asked the Supreme Court for discretionary review, and the Supreme Court said, sure, we'll take a look at it, which I don't object to, because this was a case of particular note and particular importance, and there were particularly valuable legal questions. I thought this was going to go to the Illinois Supreme Court all the time. I didn't think that Jussie would win, but what can you do? All right, so let's do some analysis. Defendant makes the following 5 arguments on appeal. He entered into a non-prosecution agreement with the state that should be enforced. Double jeopardy considerations preclude second prosecution because he's already been punished for the same offense. No. The trial court erred in denying his Rule 412 motion to compel the special prosecutor to disclose to the court for in-camera review its notes from interviews from 2 key witnesses. His sentence was excessive. No. And influenced by improper aggravating factors. And the restitution order was an error because of problems of proof and because the city of Chicago and the Chicago Police Department cannot be considered victims under the applicable statute. They absolutely can, as far as I'm concerned. Yes, the city can be a victim under the statute. That's the way I read it, at least. The Supreme Court saying we agree with the defendant's first contention and do not address the others. So they're just going to simply rule on the first ground and not rule on any additional grounds. Fair enough. Fair enough. Defendant's argument largely tracks his reasoning, or largely tracks the reasoning of Justice Lau's dissent. Fair enough. Defendant argues that he entered into the non-prosecution agreement with the state. He fully participated in his part of the agreement, and therefore any further prosecution is barred. He cites authority from Illinois and other jurisdictions in which agreements between defendants and prosecutions have been enforced in a variety of settings. Defendant contends that public policy considerations support enforcing the agreement. He argues that it's irrelevant that the first case was disposed of by way of nolle pros because the nolle was enforced or entered into by the state as part of the bilateral agreement. He cites cases in which courts have applied contract principles to enforcement of nolle pros agreements within the context of a nolle pros. Those would be cases from other jurisdictions, though, because apparently the Court of Appeals was unable to find any from Illinois. They found one from Connecticut, and I think perhaps some others, but I don't think they found any from Illinois, at least as far as I understand it. According to the defendant, if parties have bargained for dismissal of the charges, and defendant has performed his part of the bargain, the manner in which the state disposes of the charges is irrelevant. Defendant further contends that if there were any structural or procedural flaws in the non-pros agreement, Illinois law requires the agreement to be enforced if the defendant relied on the agreement, as reliance had constitutional implications. So basically, if the contract is defective, we're now going to move to principles of equity, such as promissory estoppel. That's what that sounds a lot like, right? So first, how about contract? Second, if not contract, how about not contract, like promissory estoppel? They made a promise, I relied on it to my detriment. How about that? Can we give that a shot? Finally, he argues that if the court had any doubts as to the terms of the agreement entered into, it should be remanded for a matter of an evidentiary hearing to figure out what exactly it is we agreed to, which, okay. The state counters that the record does not show that the nolle pros was entered into as part of an agreement, which, their representations before the court certainly don't reflect that. At the trial level, that was, when they made the nolle pros in the first place, way back in the day. Alternatively, the state argues that to the extent there was an agreement, it was only for a nolle pros rather than dismissal with prejudice, which is not the same thing. The state cites Illinois case law establishing that nolle pros is not final disposition and does not bar further prosecution. The state acknowledges cases that have enforced agreements between the prosecution and the defense. However, the state contends that those cases all involve the defendant waiving a significant constitutional right. The state argues that remand for evidentiary hearing would not be appropriate because the defendant failed to develop an evidentiary record establishing the non-prosecution agreement and never requested an evidentiary hearing. So basically, it's too late for that, is that counter. Finally, the state briefly argues that defendant may not challenge his re-prosecution on the basis of a non-prosecution agreement in the first case, as the circuit court found those proceedings to be void. A reviewing court considers the trial court's ultimate ruling on the motion to dismiss charges under an abuse of discretion standard, but where the issues present purely legal questions, de novo. So if they're following the law, then it's abuse of discretion, but if the law is mistaken, then de novo. Whether the defendant was denied due process and whether that denial was sufficiently prejudicial to require the dismissal of the charges are questions of law, which are to be reviewed de novo. Given the trial court summarily denied defendant's motion to dismiss without resolving any factual questions or even addressing the merits, we believe that de novo review is also appropriate because, well, the trial court didn't give us anything to work from. In Santabello versus New York, United States Supreme Court, 1971, defendant agreed to plead guilty to a lesser included offense of the crime charge if the prosecution would make no remarks on the sentence. After defendant pleaded guilty to the lesser charge, the prosecution recommended the maximum sentence, and the trial court imposed it. The United States Supreme Court vacated and remanded, holding that when a plea rests in any significant degree on the promise or agreement of a prosecutor, so that it can be said to be part of inducement or consideration, such promise must be fulfilled. Courts have also consistently enforced agreements between defendant and prosecution in a variety of other contexts. So, yeah, this is kind of standard in a lot of ways. When there is specific agreements or specific representations, the police or prosecution is bound by them, which is why police go out of their way to not make specific promises when they're doing interrogation because they know better, because they've been burned by it before. So the police and prosecution typically will not say specific things because specific things will burn them. They will say things like, if you cooperate, it will help you. What does that mean? I don't know. Neither do you. It doesn't mean anything. This will help you. This might help the judge. Maybe, this or maybe that. So it's like, yeah, they don't make specific representations because when they do, they get bound by them. Courts have consistently enforced agreements between defendant and the prosecution in a variety of other contexts. As Professor Lafave has noted, courts have enforced prosecution agreements. The charges would be dropped if defendant passed a polygraph, which, fair enough. Polygraphs are not admissible in court, but if you want to use them as part of a negotiation, I guess. Obtained a psychiatric examination, producing a specific result, ceased criminal conduct or aided a criminal investigation in some way, or even to do some additional test to be conducted at trial. Postponement agreement to the defendant did not implicate the defendant. So when there's specific agreements, there's specific agreements. In reaching these results, some courts have employed contract principles, while others have argued it would be a breach of public faith to not hold the government to its word. Okay. Fair enough. In Starks, this court, the Illinois Supreme Court, addressed a situation where the prosecution allegedly agreed to dismiss the charge against the defendant if the defendant would submit to and pass a polygraph. In his motion for the new trial, the defendant alleged that he passed the polygraph, but the state did not dismiss. The court found the record insufficient to determine whether there was such an agreement. Again, get it in writing would be really helpful, by the way. Please get these agreements in writing. It solves a lot of problems. Lawyers, I'm talking to you right now, lawyers. Lawyers, hey, get it in writing. Get it in writing, lawyers. Anyways, the court found record insufficient to determine whether there was an agreement, so it remanded the cause to the circuit court for an evidentiary hearing to resolve the question. If the circuit court determined that there was an agreement, the court directed that it implement the agreement. So we're going to go back to figure out whether there was an agreement. Get it in writing. The Starks court explained that why such an agreement was enforceable. The state's attorney is an elected representative of the people. He has been given the responsibility of evaluating evidence and determining what offense, if any, can and should be charged, Prosecutions have traditionally been afforded a broad range of discretion from which to perform their duty. The prosecution must honor the terms of an agreement it makes. To dispute the validity of this precept would surely be to result in total nullification of the bargaining system between the prosecution and the defense. Therefore, this court believes that if the prosecution did make an agreement, it must abide by the agreement in this case. Incidentally, by the way, that doesn't necessarily bind the defendant until there's a formal plea, but it does bind the prosecution. So the prosecution is in slightly worse position than the defense on this one, because the defense could hypothetically renege on the deal unless it's, been formally entered into a formal plea and accepted by the judge and all that stuff, right? But the prosecution can't renege on the deal. Due process and all that stuff. So, fair enough. Let's see, where are we? This court, that is the Illinois Supreme Court, has noted that the Michigan Supreme Court and the Florida Appellate Court have enforced similar agreements, looking to the law of other jurisdictions for persuasive authority. This court has explained that consideration was the defendant surrounding his Fifth Amendment privilege against self-incrimination by submitting to the polygraph. In the plea agreement context, this court has declined to require specific performance of agreements if the defendant has not yet pled guilty. This court has held that in this context, the defendant's due process rights may be protected by pleading not guilty and going to trial. So if that, then you might be able to go back on the deal. So fair enough. If there's been no reliance, right? If it's just a plea deal and they change their mind and there's not anything in exchange for it other than the deal, then you might be able to back out on that. Okay. Thus, in People versus Boyd, this court declined to require specific performance of a plea in which the prosecution withdrew the offer before the defendant pled guilty, which in that case would have been the formal acceptance, I suppose. The court explained that the state's repudiation of the agreement was without constitutional significance because the defendant did not plead guilty in reliance on the agreement or presumably do anything else in reliance on the agreement. This court distinguished Starks on the basis that the defendant in Starks had surrendered his privilege against self-incrimination by submitting to the polygraph, whereas in Boyd, he surrendered nothing. So in the polygraph case, he agreed to do a polygraph. And there was a polygraph that was done. So now we have performance on the agreement, right? Now we start having performance on the agreement, and arguably complete performance by one side. So those of us who remember some of our contract law principles from law school, this should be like, yeah, okay, what happens if there's no performance yet? What happens if there's partial performance? What happens if there's complete performance by one side, right? So some of these principles might be sparking some memories by some of the lawyers in chat. And it's like, yeah, okay, so we're going to just kind of do that when it comes to criminal law too. It's like, okay, so in the case of the plea agreement, he hadn't done anything yet. He hadn't done anything. The only thing he had done was promise to plead guilty. It's like, we promised this if you promise that. And apparently their promise for promise was not enough. So I guess that's a departure. That's a departure from the civil contracts. Normally promise for promise would be sufficient in a civil contract, but in the criminal contract, I guess, in the criminal contract, in the context of the plea, it is not enough. A promise for promise is not sufficient to be binding. We need to have at least partial performance, it seems. Okay, fair enough. I am amused by these slight distinctions in law. These are entertaining to me. These may be less entertaining to you as I geek out on these very slight differences. These may be less entertaining to you as I geek out on the very slight differences that exist between contract law principle in the criminal context versus the civil law context. Please bear with me. All right, let's move on. In People versus Smith, the appellate court addressed the situation in which charges addressed by the defendant have been dismissed by the prosecution in exchange for a defendant providing assistance to undercover police in making purchases of cocaine. When the state filed new indictment against the defendant, the court dismissed the indictment, finding the reinstating the charges violated due process. The appellate court rejected the state's request for an evidentiary hearing pursuant to law to determine if there was an agreement and what the terms were. The court held that the remand was unnecessary because, unlike Starks, the agreement was set forth in a court transcript. Well, someone put it in writing. It was the court itself who put it in writing, but damn, like, right? It's like, hey, defendant, we'd like to dismiss these charges against you. Would you like the charges against you dismissed? Boy, oh boy, would I ever. Hey, all you have to do is go sell some drugs for us and we'll drop the charges. Okay. And the court stenographer is recording all this. So it's been reduced to writing because we have a court stenographer in the room. So we don't have to have a hearing because the court stenographer was doing the typey thing. Fantastic. After holding the new indictment violated both defendants' due process rights and the prohibition against double jeopardy and were barred by res judicata, holla, res judicata, can I get a what from my law bros? The appellate court held that the trial court judgment could also be affirmed on the ground defendants have fulfilled their part of the agreement, which the court could enforce as an executed agreement. Well, there is an agreement. It's been executed. We have performance on the agreement. The state, relying on Boyd and Narvali, argued the state was not bound to honor the agreement. The appellate court disagreed, holding that Boyd and Narvali involved plea agreements, while the case before it involved a cooperation immunity agreement. Different kinds of contracts. I love it. It's like, yeah, this. You will not study this in contract law in law school. This is you probably won't. Yeah, this is a whole new world of stuff, right? So it's like, instead of a contract for goods or a contract for services, hey, does this contract need to be evidenced by writing? I don't know. Is it a contract that takes more than a year to perform? Is it a contract in contemplation of marriage? Is it a contract for land? Is it a contract to assume the debt of another? Is it those kinds of contract? We need evidence of it in writing. Oh, so now instead of those kinds of contracts, we have these kinds of contracts. We have plea agreements and we have cooperation agreements, all kinds of contracts, so many kinds of contracts, so much fun. Do you like contracts? I got contracts for your contracts, baby. So maybe the soft sits, see, the soft sits are onto something. Don't tell them that though. Soft sits are onto something. Don't tell them that. It's all a matter of contract. Yeah, it kind of is, but then there's that sort of the big caveat, which I mentioned earlier. What is the big caveat? What is or is not a contract is a matter of state law. So your agreement may not be required at all. Congratulations to the social contract. You are now a participant. I hope you enjoy. Anyways, pressing on. The court distinguished two situations as follows. The due process clause, due process implications are different. In a plea agreement scenario, if the defendant has not yet pled guilty, he may proceed to trial, which, fair enough. He's not pled guilty, right? Here, because it's violation of the right not to be hauled into court at all, which operated to deny the defendant's due process law. So there was an agreement that we wouldn't prosecute. So the very fact I'm in court is the violation. Fair enough. The court also found it significant that the case involved an agreement that had been approved of by the trial court. That doesn't hurt. The trial court had dismissed the indictment on the state's motion. The court found that Starks, rather than Boyd and Narvola, was the appropriate precedent. The defendant in Smith, just like the defendant in Stark, had fully performed on their bargain. Full performance by one party? Does that mean it's unmodifiable as a matter of law? Okay. The new charges filed against the defendant violated the due process. The court also noted that another appellate court decision, People versus Schmidt, had allowed the state to violate its part of a cooperative immunity agreement, or allowing that would constitute judicial approval of the government violating an agreement, a reprehensible aberration. Whoa. Good stuff. In Skapansky, This court agreed with the Smith court assessment of how plea agreements are different from other types of agreements entered into by the prosecution and a defendant. It's a special kind of contract, of course it is. So many exceptions. The one thing you learn about law, the one thing you learn is exceptions and exceptions to exceptions and exceptions to exceptions to exceptions. It's one of the things. It's why the answer to every legal question is it depends, because there's so many asterisks. Oh, Lord. In this case, the trial court dismissed the charges against the defendant after finding the indictment violated the due process rights as well as cooperation agreement he entered into with the police. The court concluded the defendant had entered into a valid oral cooperation agreement that if the defendant cooperated in arrest of certain individuals, he not be charged. The court also found the defendant's due process rights were violated because he fulfilled his part of the bargain and incriminated himself in the process. A divided appellate court reversed and remanded. This court reversed the appellate court and affirmed the circuit court. On appeal to this court, the state acknowledged that in Starks, the court had held that due process requires the state to honor its agreements it makes with the defendant when the defendant has fully performed. However, the state contends that its officers did not have authority to enter into the agreement without approval of the state attorney. The state contended that the state is not required to specifically perform a police officer's unauthorized non-prosecution agreement. All right, so this non-prosecution agreement is being made by a police officer as opposed to the prosecutor. And the court's not going to care. The court's not going to care. It's like, look, either way, there was a specific representation made. Either way, the defendant relied on it. So if they're random police officers making specific representations, then you can rely on them. Now, proving those specific representations is a whole nother set of problems, right? Which is why I get it in writing, because the officer can be like, oh, there's no agreement. I don't know what they're talking about. I never said anything like that. Right? But in principle, the state, the police officer is an agent of the state. The prosecution is an agent of the state. The agent has the power to bind the principal, which is to say the state. Now we've moved into agency law. I know you're all excited. We've moved from the wonderful world of contract law into the new exciting world of agency law. Ooh, fun and exciting. The court explained how cooperation agreements differ from plea agreements. In a plea agreement, the detrimental reliance is the waiver of the right to trial, whereas in a non-prosecution agreement, defendant's cooperation is sufficient for consideration for the government's immunity promise. Moreover, due process implications in each scenario are different. In the plea agreement scenario, if the defendant has not yet pled guilty, he still has the option of going to trial. With the cooperation agreement, the violation of the right not to be hauled into court is what denies due process. This court further explained that cooperation agreements are analyzed under contract law principles, holla, and that the principle for enforcing them is the due process clause of the 14th Amendment. The Supreme Court of Illinois has stated, generally, fundamental fairness. Fundamental fairness. Are we bringing another legal concept into this doctrine? Are we bringing another legal concept of fundamental fairness? Okay. We're mixing our legal standards over here. Generally, fundamental fairness requires promises made during plea bargaining and analogous contexts be respected. When the government has entered into an agreement with the prospective defendant, and defendant has acted to his detriment or prejudice in reliance upon the agreement as a matter of fact conduct, the government ought to be required. That sounds suspiciously like promissory estoppel. Which, fair enough, right? I don't really have a contract with you, but I've caused you to do something in detriment, so you have the ability to rely on it. So we've moved from principles of law into principles of equity. Fun. So yeah, we got all kinds of stuff, right? We're talking about like ought to be required to make the agreement under fundamental fairness in equity. Oh man, so many legal concepts coming together in a nice little melange. It's great. This court noted that the essence of the due process of fundamental fairness and cited People v. McCauley for the proposition that due process is implied whenever the state engages in conduct towards a citizen deemed oppressive, arbitrary, or unreasonable. This court held dismissal of the indictment was appropriate because defendants' due process rights were violated when the state breached its agreement. The Stepanski court also rejected the state's argument that the agreement was unenforceable because the police did not have the authority to bind the state's attorney. The court noted that the trial court had found that the defendant fulfilled its obligation under the agreement and its due process rights were violated when the state later charged him. The court held that under these circumstances, it did not matter whether the agreement was valid in the sense that it was approved by the state attorney. The court explained that an unauthorized promise may be enforced on due process grounds if the defendant's reliance on the promise has constitutional considerations. So this would be like a parent agency if we want to move into, if we want to move from a criminal law context into a civil law context, we'd be talking about a parent agency as opposed to actual agency. Right? So, okay, so this person's actually your agent. Well, what if they're not your actual agent? What if they're just apparently your agent? And what then? So how do we deal with that, right? An apparent agency. So, yeah, we can blend these concepts together, man. It's great. Mariko in chat says, you looked up promissory estoppel and my brain did not have enough RAM to absorb the concept. I'll tell you what, man, we're bringing all kinds of legal concepts into this thing, man. We're talking about agency, actual agency, apparent agency, due process, fundamental fairness, equity, law, contract. Bring it all, baby. Bring it all. It's all good. Nate the lawyer says apparent authority for the DA. This is crazy. I know, Nate. I know. Apparent agent for the DA. Ah, man, that's good times, man. Hit me with that law, Jeans. Ah. All right, as the defendant had suffered a prejudicial violation of due process, dismissal of the indictment was appropriate even if police did not have authority. So no actual authority, but apparent authority. Detrimental reliance, promissory estoppel to an apparent but not actual agent, go. What a great bar exam. What a great final exam problem for some law school somewhere. Go. This is great. If defendant is correct that the initial charges were dismissed as part of an agreement to which the state has fully performed, the above authorities would support the agreement. Therefore, we proceed to consider the following questions. First, was the nolle process entered because of an agreement? Second, if so, what were the terms of the agreement? And third, what was the legal effect of the agreement? Great. Issue number one, the nolle process was entered as part of an agreement. The state briefly contends that there's no evidence that Miss Fox, what does the fox say? What does the fox say? Corruption, 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 corruption is what the fox says. That's how the song goes, right? Corruption, corruption, corruption. Okay. There's no evidence that the state attorney moved for a nolle process part of any agreement. The state notes that when assistant state attorney read the statement about the nolle process, she referred to defendant's volunteer service. Again, less volunteer than maybe otherwise apparent. The state also argues defendant forfeiture of the bond was voluntary. That the nolle process was entered into as an agreement with defendant is clear from the record. Again, when the nolle process was entered, the assistant state attorney said, after reviewing the circumstances and fact of this case, including Mr. Smollett's voluntary service in the community and agreement to forfeit his bond, to the city of Chicago, the state's motion with regards to the indictment is to nolle pros. We believe the outcome is a just disposition and appropriate resolution of the case. The state contends the defendant admitted that forfeiture of the bond was voluntary. However, the portion of the record the state cites in support of this proposition is the sentence from defendant's motion to dismiss the indictment on double jeopardy grounds, which began that under the circumstances where the bond was voluntarily submitted as a condition of dismissal. This is fully consistent with defendant's position. The charges were dismissed as part of an agreement. Moreover, defendant points out the only other interpretation of prosecution's word is the defendants charitably agreed to give up $10,000 bail at the exact moment the prosecution can coincidentally dismiss the case. This is obviously not what happened. Well, in so much as I believe that Jussie Smollett may not be capable of an act of charity, I would be forced to agree. Although we think it's clear from the assistant state attorney's statement alone that nolle pros was entered into as part of the agreement with defendant, we note the record contains even more support for the conclusion. In Judge Tuman's order appointing the special prosecutor, he specifically addressed the negotiations the parties entered into over the resolution and wrote there was no admission of guilt or plea when the agreement was consummated. Consummated? Bow chicka bow wow. Well, I am quite sure the agreement was consummated because the people got fucked. Moreover, the special prosecutor's own investigation revealed an agreement between the parties. The special prosecutor's summary report of the conclusions and findings of the investigation, which the trial court made public as part of the special prosecutor's request, is in the record. In the report, the special prosecutor states that the interviewed defendant's lawyer was negotiated the resolution. Moreover, the special prosecutor found there was a conflict over who negotiated the terms of the resolution with Mr. Smollett's lawyers. We don't even know. No idea. Two different assistant state attorneys each stated that the other one negotiated the terms. Law. And defense counsel offered her version of which state attorney she negotiated the resolution with. The report also notes a discrepancy between two assistant state attorneys over when the state attorney began discussing resolution with the state's counsel. The report also states that the first assistant state attorneys offered terms to the defendant, which he ultimately accepted. Okay. Additionally, the report quotes a press release the state attorney issued when it dismissed the charges. In the press release, Kim Foxx states that it dropped the charges in return for defendant's agreement to do community service. Again, 15 hours for 16 charges is a great deal. Where do I get this deal? Where do I get the Kim Foxx special? That's what I want to know. Where do I get this deal? That's what I want to know, ma'am. The press release further states that without completion of these terms, the charges would not have been dropped. Sure. Finally, the report notes that the statement that the assistant state attorney read into the court was drafted in conjunction with the defendant's attorney. As the the special prosecutor's own report shows, there's similarly no credible argument dismissal was not entered to as part of the agreement. Fair enough, I suppose. It's a corrupt agreement. It's corrupt. The entire thing is corrupt. It's a bullshit agreement. But sure, there was an agreement between two corrupt assholes. We'll try to figure out who's the more corrupt asshole between them both. It's hard to tell. On the one hand is Kim Foxx, and the other hand is Jussie Smollett. Who's the bigger asshole? Who is more corrupt? Hard to tell. Maybe it's a match made in heaven after all. Or maybe they're just both products of Chicago. Could be worse. They could be from Louisiana. The basic terms of the agreement are clear from the statement the assistant state attorney read on March 26, 2019. Community service and bond forfeiture on defendant's part and dismissal on part of the state. The complete terms of the agreement are set out more detail in the special prosecutor's summary report of its finding and are virtually identical to those set forth in the information release. According to the special prosecutor's report, the state attorney, Ms. Foxx, made the decision to resolve the charges as follows. And I believe we read that part, so we won't read it again. The Office of Special Prosecutors report specifically refers to as the terms of dismissal. It's equally clear that the parties intended finality. The state disagrees with this conclusion, relying on the boilerplate principle that null pros is not final disposition of a case and does not bar prosecution for the same offense. Thus, according to the state, the dismissal of the charges via null pros shows the party did not intend finality. The state argues the defense attorney remained silent when the prosecution announced dismissal by the null pros shows the party did not intend dismissal with prejudice. Why would the defense lawyer open their mouth when you're giving them everything they want? Why would they give you everything when you're giving them why would the defense lawyer open their mouth? In response to a question at oral argument, the state contends its argument that the parties did not enter into a non-prosecution agreement, but rather a not prosecute you today agreement. In other words, the state attorney refiling charges the day after defendant forfeited his $10,000 bond would have been perfectly in keeping with what the parties intended when they entered. We disagree. We agree with Justice Lyle that the assistant state attorney's statement on March 26, 2019 clearly showed that parties intended finality. Again, the assistant state attorney stated that the outcome was a just disposition and appropriate resolution to the case. This is not a statement of someone who intends to refile the charges, as cogently explained by Justice Lyle. While the state could have exercised greater semantical precision on the record by stating the case was terminated with no intention of refiling, from the record it's apparent that this was the intent. Any argument that suggests the state had no intention of dismissing the case as a conclusion and disposition of the proceeding fails. The intent of the prosecutor exercised the authority of the state in crafting and tendering its agreed disposition to the trial court was evident. The prosecutor stated that they believed the outcome was just disposition and appropriate resolution. Merriam-Webster, really? Really, Merriam-Webster? Or what are we doing, a graduation speech? Merriam-Webster defines the term disposition as the act or the power of disposing or the state of being disposed. Wow, that was so worthwhile. I'm really glad we took the time to do that. Those words denote finality that would not have existed if the state merely sought to refile the charges. In reality, there's no indication in the record or in any brief the Cook County Sheriff's Office or Attorney's Office had any intention to reinstate the charges. However, the state could not have predicted the public outcry precipitating the unprecedented appointment of a special prosecutor who would violate its lawful agreement with impunity. Ordinarily, when the state disposes of a case, this case file stays within the exclusive control and possession. Wow, this person knows how to write. I do appreciate this person has a very English major, a very lyrical almost writing style. It's certainly not my writing style, but I appreciate it nonetheless. A very sophisticated and imagery heavy sort of writing. I do like it. It's good. Not my writing style. My writing style is more burn it down, sarcasm, and wit. The intent of finality is also evident in the terms of agreement as set forth by the special prosecutor. Oh, Lord. In its report, the special prosecutor states that the only punishment defendant would receive would be 15 hours of community service. Again, I want to know where to get this deal. I really do. And forfeiture of the bond of $10,000. Using the words punishment and restitution connotes a case that is at its end, not one in which the state intends to continue to pursue. Every time the special prosecutor had a chance to describe the terms of the agreement, it described it as a complete dismissal in exchange for punishment and restitution. The special prosecutor also noted that the parties agreed the defendant would not have to plead guilty and would not have to participate in the deferred prosecution. Not even an admission on the record. Not even I'm a sorry. Is it too late to say I'm sorry? Again, these statements connote a case that's been resolved rather than one that's ongoing. The parties intend finality is also supported by page after page of the special prosecutor's summary report. There's no indication anywhere in the report that the special prosecutor, the state attorney, considered the case resolved. For instance, the special prosecutor stated that after the case was dismissed, there was media speculation about whether something improper had been going on behind the scenes. Oh no, not in my Chicago. To allow the defendant to achieve the particular resolution he received. Pretty much, yeah. The special prosecutor discusses an interview with the state's attorney, Fox, in which she said she was surprised by and disagreed with how the case was resolved. Bullshit. She believed community service should have been related to the offense and defendant should have been paid more than $10,000 in restitution. She further stated that if the defendant was not going to be required to plead guilty, he should have first been required to admit the facts of the wrongdoing. She also told the special prosecutor she believed the case was resolved this way because they wanted the guy out of town, because of the flurry activity at which the courthouse and throngs of people were coming to court. The special prosecutor also stated that if it interviewed lawyers who currently or previously worked in the special attorney or the state attorney's office's criminal division, who were surprised and shocked by at least some facets of the dismissal terms. I think some of these facets have occlusions. Ho ho ho. Look at what Uncivil just did there. Uncivil did a fun diamond pun. How nice. If you like fun, unexpected diamond puns, please make sure to hit that like button. The OSP also explained the various ways that resolutions defendant received did not track the requirements of deferred prosecution program. Additionally, the special prosecution set forth the following quote from a press statement issued by the state's attorney. In the last 2 years, the Cook County State's Attorney's Office has been referred to by more than 5,700 cases for alternative prosecution. Yeah, but this wasn't one of them, though. This was its own thing. This is its own stupid thing. This is not new or unusual practice. It is in this situation, it was. An alternative disposition does not mean there were any problems or infirmities with the case or evidence. We stand behind the Chicago Police Department's investigation and our decision to approve charges in this case. We did not exonerate Mr. Smollett. Are you sure? Are you sure about that? The charges were dropped in return for Mr. Smollett's agreement to do community service and forfeit the $10,000 bond. Without the completion of these terms, the charges would not have been dropped. The outcome was met under the same criteria that would have occurred for and is available to any defendant with similar circumstances. Bullshit. I want to know where my $10,000 and 15 hours community service in exchange for 16 felonies deal is. That's what I want to know. Can I get them in advance? Can I get them as IOUs? Will the government sell me them today? Can you sell me an indulgence today for a burger on Wednesday? Or whatever the analogy is in this circumstance, whatever. I would like my 16 free get out of jail cards. That'd be great. All the above statements indicate the case has not been resolved, not one in which the further prosecution is contemplated. Indeed, nothing has happened after the initial case was dismissed makes sense if continued prosecution was contemplated. If, for instance, the state attorney had null pros the case because of evidentiary problems that would require further investigation before prosecution could proceed, there had been no public outcry. A retired judge would not have sought appointment of the special prosecutor. If further prosecution by the state attorney were contemplated, Judge Tuman would not have argued the disposition shocked the officialdom as well as the community. The office of the special prosecutor, the acronyms are problematic, and remembering which acronym is which is getting. I've slipped up a couple times on which acronym is which. It's challenging. Just bear with me. We're doing our best. The special prosecutor would not have stated a press release that disagreed with the state attorney resolving the case and contended that this position was similar to how the state attorney had disposed of similar cases. All those things happened because the previous case had been resolved. Finally, it defies credulity to believe the defendant would agree to forfeit $10,000 with the understanding the state attorney would simply re-indict him the following day. As Justice Lau noted in her dissent, while a defendant might appreciate the gift of a nolle when not part of an underlying negotiation, why would a defendant bargain for uncertainty? When negotiating a disposition, a defendant is bargaining for certainty, a cooperation agreement, or deferred prosecution agreement rather than rolling that dice with trial. Because the charges were dismissed in exchange for defendant's community service and forfeiture of his bail, and because defendant fully performed his end of the agreement, the state is bound. The state contends that the most relevant authority is Boyd. We disagree. Boyd involved a plea agreement the state backed out of before defendant had entered a plea in reliance on the agreement. As Stapinski explained, due process considerations are different in a plea agreement sitting. Moreover, Boyd court distinguished Starks on the basis the defendant in Boyd had surrendered nothing in reliance on the agreement. Here, a defendant surrendered $10,000. Because the case involves an agreement to dismiss charges in exchange for defendant doing something, and defendant did what is required, Starks and Stapinski provide the relevant precedent. Okay, I just need a moment to breathe. Just need a moment to breathe because I've been reading for a while now. How y'all doing, chat? You doing well? I just like to kindly remind you to hit that like button. It helps to make the channel, grow and stuff, and spread word of the channel and stuff. And you can always retweet it or share information about the channel with your friends. All that stuff is appreciated. I love doing this for you, especially when we have cases that are like this legally interesting. And then I get to geek out on multiple legal principles. I had professors who really hated that in law school. But I always thought it was, I liked it. I always liked, taking principles from disparate areas of law and seeing how they meld. And some law professors really hated that, but I liked it. It's like, how do I take this contract law principle and apply it in this criminal prosecution? Or how do I take this and apply it over here? Like, how do you make things interrelate? And I think things more interrelate than sometimes some of the professors even give credit for, because it all sort of flows from a logic, or at least it does to me. So anyways, I enjoy it. I appreciate you being here. I did not get my chest shoulders yesterday. No, I didn't go yesterday. I decided to take one more day off, but I will go today, and I'll do whatever the Thursday exercise is. So I'll probably just skip chest and shoulders this week. Although, you know what I might do instead? Instead of skipping it completely, I might just add like part of it to my workout today. So I'll just like do part of Wednesday's workout today. That makes more sense. So I still, because I'm working different muscles, so I'll just do part of it today. And that way I get my entire week's work done. So I'll still get it done. Yeah, at least it wasn't leg day. Man, 1,200 pounds is impressive. Like, yeah, my best is 3 times 10 at 740. I'm not sure what like my 1 rep PB would be, but I'm sure I could do like 800, but I don't know about more than that. So 1,200 for reps. 1,200 for reps. Yeah, I don't see 1,200 for reps anywhere in my immediate future. Maybe later. I'll get back to you. My fantasy is 405 bench, which probably won't happen, but that's sort of my fantasy is 405 bench. Right now I'm just doing dumbbell bench. I'm not even doing bench press, but I was doing like 65 pound or dumbbells or something. So we're making some progress. Oh Lord. Because our case involves an agreement to dismiss charges in exchange for defendant doing something, and defendant did what the agreement required, Starks and Stapinski provide the relevant precedent. 1250, fair. Again, Starks involved an alleged agreement between prosecution and defendant, whereby the state would dismiss charges if defendant passed a polygraph. The court state, okay, we read this part. Okay, let's skip to here. The state contends that the above cases are distinguishable, and the defendant in those cases surrendered constitutional rights in exchange for dismissal. By doing so, the defendants were hampered in their ability to defend themselves against future charges. Here, by contrast, defendants' reliance was forfeiting a $10,000 bond rather than constitutional right. The state contends that the bond forfeiture was voluntary and the voluntary forfeiture of the bond is fundamentally unlike a waiver. We disagree with the state for several reasons. First, we've already explained defendant's assertion that the bond forfeiture was voluntary was based on a sentence from defendant's motion to dismiss where the defendant stated the bond was voluntarily forfeited as a condition of dismissal charges. In other words, the bond was forfeited in reliance on agreement with the state. Indeed, in Special Prosecutor's own report, the bond forfeiture is described as a requirement. Second, the court explained that Starks, for why the state was required to honor the agreement, was not based on defendant surrendering the constitutional right. The rationale was as followed. The prosecution must honor the terms of the agreement it makes with defendants. To dispute the validity of the precept would surely be to result in total nullification of the bargaining system. 440 bench? That's pretty impressive. 440 bench. Nice. Dispute the validity of the precept would surely be to result in total nullification of the bargaining system between prosecution and defense. Therefore, the court believes that the prosecution did make agreement with the defendant. It must abide by the agreement of the case. In the passages the state relies on, where the court discussed the defendant surrendering its Fifth Amendment privilege against self-incrimination, this court was addressing the state's argument that the agreement was merely a gift-type bargaining, lacking consideration. The court rejected the argument on the basis the defendant's waiver of the privilege against self-incrimination was consideration. The court was simply addressing what consideration was in the case before it. Nothing in Starks even remotely suggests the forfeiture of $10,000 could not be adequate consideration to enforce the agreement. Well, I mean, fair. To say $10,000 is not sufficient consideration would be kind of weird. That's fair. Similarly, in Stepanski, when explaining why the state was required to honor its cooperation agreement, the court relied entirely on contract law principles, due process, and fundamental fairness. The court was quite clear that where the government has entered into an agreement with prospective defendant and defendant has acted to his detriment or prejudice in reliance upon the agreement as a matter of fair conduit, the government ought to be required to honor the agreement. Nowhere in discussion whether the defendant's due process rights were violated by the states did the court say anything to suggest the only enforceable agreements with the state are those in which the defendant waives a constitutional right as consideration. Later, in addressing a different argument, the Stepanski court referred to a defendant's reliance having constitutional consequences. There, the court was responding, did Matt Gaetz drop out? I mean, I'd prefer Solicitor General, but I'll take AG if Trump is looking for a new AG. I mean, I'd prefer Solicitor General personally, but if he needs somebody, I'm available. Plus, as AG, I'm sure I can get my way into a Supreme Court case. That'll be fine. The court has rejected the agreement stating that unauthorized promise may be enforced on due process grounds if defendant's reliance on promise has constitutional consequences. The court explained defendant had relied on non-prosecution. He withdrew his nomination. Oh, that makes sense. Yeah. No, I mean, Preligard's going to leave with the new administration. Yeah, the Solicitor General is a political appointee, so she's going to leave. I want to take over for Preligar. I want to be the new Preligar. The court rejected the argument, explained that unauthorized promise may be enforced on due process grounds if defendant's reliance on promise has constitutional consequences. The court explained defendant had relied on the non-prosecution agreement he made with police and incriminated himself in the process. Thus, he had suffered a prejudicial violation of due process. In that passage, the court was specifically addressing the circumstances in which the unauthorized promise is enforceable. Regardless, the state reneging on its agreement after the defendant had forfeited $10,000 bond obviously had constitutional consequences. Stepanski explained that due process is a fundamental premise of our system of justice, designed to protect an individual's person and property rights from arbitrary and capricious governmental action. The court further stated that due process is implicated whenever the state engages in conduct towards its citizens deemed oppressive, arbitrary, or unreasonable. The court further stated due process. Okay. Moreover, because the essence of due process is fundamental fairness, due process essentially requires fairness, integrity, and honor in the operation of criminal justice and its treatment of the citizens' cardinal constitutional protections. Cardinal, huh? Cardinal. Interesting. Like religious. Okay. Interesting. I mean, that's fair. All right. Where are we on this thing anyway? I'm on page 23 of 32. All right. Okay. The next question is whether, despite what the parties may have intended, dismissal of the charges by way of the nolle pros allowed the state to bring new charges against the defendant. The state argues that further prosecution was not barred because the first case was dismissed by way of the nolle pros. The state cites People v. Daniels for the proposition the nolle pros is not final disposition and will not bar further prosecution. The state further argues, citing People v. Gill and People v. Ryan, that the court may not infer the dismissal of charges with prejudice. Rather, the record must affirmatively show the prosecution's intent. The rule that the state relies on, the defendant may be prosecuted after a nolle pros, has never been absolute. Rather, as the court has stated, we've previously held that if a nolle pros is entered into before jeopardy attaches, the state may re-prosecute the defendant subject to other relevant statutory or constitutional defenses. As we've already explained, Illinois law establishes that it's fundamentally unfair to allow the prosecution to renege on a deal when the defendant has relied on the deal. Okay. Moreover, none of the cases cited involved a nolle pros that was ordered into as part of an agreement. In Calberg, the Supreme Court of Connecticut explained the difference between unilateral nolle and one that's entered into bilateral. So now the Supreme Court of Illinois is citing the Supreme Court of Connecticut with approval, which, that's one of the things that law does, man. That's how law goes. And I believe we read this part already from the decision before, so we don't need to read that part again. The Calberg court enforced an agreement where the prosecution agreed to nolle pros 4 felonies in exchange for the defendant agreeing to make a donation of $271. Am I reading that right? I certainly am. To the Connecticut Criminals Injuries Compensation Fund. These are the most generous pleas I've ever heard of in my life. Okay, you're charged with 4 felonies. How about you give us $271? Not $270, mind you. $271. It's that extra dollar that lets you know they're really serious. Wow. At oral argument, defense counsel was asked whether the court had ever recognized a distinction between unilateral and bilateral. Defense counsel noted that this court, I believe I'm not sure which court we're referring to. I think we're talking about Illinois Supreme Court. Had not used those precise terms, but argued the distinction was implicit in the court's case law. We agree. While it's true that no Illinois court has used the term bilateral nolle, this court has clearly recognized the principle that a nolle entered into in a part of an agreement bars prosecution. I couldn't get out of a traffic ticket for $270. But 4 felonies, no problem. This court's opinion in Starks was grounded on out-of-state cases that barred further prosecution after a nolle prosecution because the state had breached the terms of the agreement. In Reagan and Butler, the initial charges against defendant had been dismissed via nolle pros, and in both cases, the court held further prosecution was barred because of an agreement between prosecution and defense. Moreover, Stark itself was a case in which the parties had bargained for nolle pros. I'm kind of hungry for lunch right now. I'm not going to lie. As we discussed above, this court in Starks remanded the case to trial court for an evidentiary hearing to determine if the parties had entered into an agreement to dismiss the charges if defendant had passed a polygraph. On remand, the trial court had found the state had failed to fulfill its promise of nolle pros if charges defendant passed the polygraph. In accordance with the court's mandate, the trial court dismissed the charges. The appellate court affirmed. The court rejected state argument. How about Mike Lee for Attorney General? He'd be good. Senator Lee? He'd be good. As long as we're posing names. The court rejected a state's argument that it was unfair to enforce such pretrial negotiations. The court held that because defendant fulfilled its part of the agreement, the state was required to fulfill its part of the bargain. Neither the trial court nor appellate court put any significance on the fact that the prosecution had promised a nolle pros in exchange for defending passing the polygraph. Rather, they both acknowledged the defendant fulfilled its end of the bargain means the dismissal of charges was required. Case law thus establishes that if this dismissal was entered to as part of the non-prosecution agreement between the state and defendant, the matter of dismissal is not important. Dick Hartputlian? No, Tony, you're not helping. In fact, this court had been recognized the principle long before Starks. In People versus Balwowski, the court had allowed the defendant, who testified as co-defendant, to withdraw his guilty plea after concluding the state had breached the cooperation agreement. As part of the analysis, the court noted that the cooperation immunity agreement could be perfected by entering the nolle pros. The English practice of continuing the case after an indicted accomplice who turned state evidence and testified against his confederates to enable him to obtain a pardon, which he may plead in bar of the indicted, has never prevailed in Illinois. Do I have power to time? Yes, I do. I can time Tony out. Tony gets timed out for 10 minutes. Bad mod. The government is bound. Lol. The government is bound by honor under circumstances to carry out the understanding or agreement by which the witness testified and admitted in doing so of his own turpitude. If the district attorney shall fail to enter a nolle pros on the indictment against the court, they will consider application can be made for a pardon. The court would suggest that to discontinue the prosecution in shorter and better mode. Oh. The people acting through their duly constitutional authorities reached an agreement which the defendant at the time motion made to strike the indictment. In pursuance to the agreement, the people accepted $21,000 from the defendant in open court. In following December, were paid $13,000 in one sum on the back tax account, and subsequent amounts were paid about $10,000 or more. In view of the subsequent payments by defendants, the prosecuting attorneys are honor bound to carry out the terms of their agreement. If the administration and prosecuting agencies of the people fail to keep their legitimate agreements, public policy and the great ends of justice require the court to prevent the breaches of faith. We then disagree with the state's position that the dismissal of the first case by nolle pros means the state was allowed to bring a second prosecution against defendant. Because the initial charges were dismissed as part of an agreement with the defendant, and defendant performed the agreement, the second prosecution was barred. The parties bargained for a dismissal, and the nolle pros was simply the means by which they effectuated. To see the extreme unfairness arising from the state's position, consider a hypothetical in which the terms of the agreement were different. For instance, assume that the terms were along the lines of what the state attorney, Fox, told the special prosecutor they thought the terms were. In exchange for a dismissal, defendant admitted facts of wrongdoing in open court, agreed to do 100 hours of community service working with the victims of hate crimes, and voluntarily make $130,000 in restitution to the Chicago Police Department. After defendant performed the community service and sent the $130,000, the state dismissed the charge by way of nolle pros. If the state's position is correct, that means the state then could file a new indictment against defendant and seek the maximum prison sentence. The state has not cited any authority that would support such conclusion. We echo Justice Lyle's point about the terrible policy consequences that would follow from adopting the state's position. Justice Lyle noted that Cook County Court administrative orders on deferred prosecution agreement direct the charges should be dismissed by way of nolle pros upon successful completion of the program. The court shall be advised in the premises and state shall nolle pros all charges against the candidate. Okay. Such a result would be completely untenable. As the court held in State versus Platt, deferred prosecution agreements are contractual nature, and allowing the government to rescind the agreement after the defendant has performed would comport neither with ordinary contract principles nor with more expansive notions of fundamental fairness that control the relations between state and its citizens. It's simply never been the case that disposition by way of nolle pros always means the state can bring new charges, and we decline to adopt such a rule. Finally, the state makes a brief 3 cents argument defendant may not make an agreement based on a non-prosecution agreement in the original case because Judge Tuman found the proceedings to be void and deficient, did not appeal from the order. We disagree. A circuit court's mere use of the word void to describe another circuit court's judgment would not make it so. The court recognizes only 2 circumstances in which a judgment can be considered void: when it's entered into by a court that lacks personal or subject matter jurisdiction, or when based on a statute that's facially unconstitutional and void ab initio. The most recent cases cited by Judge Tuman thus reject the proposition from earlier cases that prosecution by an improper prosecutor is null and void. As explained by the court in People v. Woodall, any defect in an attorney appointment process or his or her authority to represent the state's interests on a given matter is not fatal to the circuit court's power to render judgment. The right to be prosecuted by someone with proper prosecutorial authority is a personal privilege that may be waived if not timely asserted by the court. In People v. Jennings, the court relied on Woodall to hold defendants was not entitled to have his conviction overturned because of prosecution's defective commission to prosecute because he never objected to the court's recognition of the person as a prosecutor. In every case cited by Judge Tuman, it was the defendant who was arguing the prosecutor was not authorized. Here, the defendant has never made that argument because that'd be really dumb. The proper prosecution role exists to prosecute defendants, not allow the state to take advantage of its own errors to do a do-over. Regardless, even if we accept Judge Tuman's reasoning, the original proceedings were void because there is no state's attorney. When those proceedings took place, the effect on the defendant is exactly the same. He performed his end of the agreement and forfeited $10,000. If previous proceedings is null and void, defendant could rightly wonder what happened to his $10,000. We specifically held in Stepanski that it's not important whether cooperation agreement the defendant entered into with the state was valid, as the unauthorized promise may be enforced on due process grounds if defendant's reliance on promise has constitutional consequences. Here, defendant entered into the agreement with fully licensed attorneys of the state, who, even if they did not have actual authority, unquestionably had apparent authority. There's that agency principle again from apparent authority. Any reliance on that agreement to his detriment. We've also already concluded that his reliance has constitutional consequences. Defendant was thus not foreclosed by Judge Tuman's order from raising his argument about the non-prosecution agreement. We are aware that this case is generating significant public interest, and many people were dissatisfied with the resolution of the original case and believed it to be unjust. Nonetheless, what would be more unjust than the resolution of any one criminal case would be holding this court that the state was not bound to honor agreements to which the people have detrimentally relied. As the Supreme, we're citing Cosby now. We're literally citing Cosby. That's hardcore. I appreciate it, but I'm just like, wow. As the Supreme Court of Pennsylvania recently stated when enforcing a prosecutorial promise not to prosecute, it cannot be granted that society holds a strong interest in the prosecution of crimes. It's also true that no such interest, however important, can ever eclipse society's interest in ensuring the constitutional rights of the people are vindicated. Society's interest in prosecution does not displace the remedy due to constitutionally aggrieved persons, citing Cosby. Hardcore. The court further notes the consequences of failing to enforce prosecutorial promises when defendant had relied on them. A contrary result would be painfully untenable. It would violate long cherished principles of fundamental fairness. be antithetical to and coercive of the integrity and functionality of the criminal justice system. We reverse the judgment of the criminal court, reverse the judgment of the circuit court, and remand the cause with directions for the circuit court to enter a judgment of dismissal. Judgment reverse. Case remanded with directions. Well, that's it, I guess. That's the end. So Jussie is free. Jussie does not have to go back to prison. The juice is loose, and he may now, and I guess he could theoretically sue for unlawful imprisonment. Would just be the cherry on this cake, right? Because he was held unjustly. So he could sue for his 4 days in lockup. Man. Or maybe he'll just make a nice tidy settlement. I wonder what they might settle for. I wonder if he might sue them and what they might settle for. I wonder if they might settle for $10,000 just to bring this whole thing back around again. Oh, Lord. So that's all good. All right, my friends. Well, that will bring us to the end of the stream. I'm hungry, and I'm going to grab some food, and then I'm going to go work out because I didn't work out Tuesday. And I didn't work out Wednesday because Wednesday's my normal day off. But I'm feeling better, and I'd like to go work out. And I think I'm going to throw in some chest exercises from Tuesday into today's workout so that I can try to get at least something of that done. Probably do some flies or something. And maybe some bench or something. I don't know. We'll see what we can do. But yeah. So that'll bring us to the end of the stream. Yeah, go have a Subway sandwich in honor of Jussie. Go have a Subway sandwich in honor of Jussie. I've been on Civil Law. Until later, my friends. Thanks for dropping by. Thanks for dropping by. Thanks for being part of the stream. I really do love you guys. I love you all. Even Tony, even if he sometimes irritates me. Tony's a good mod, even if he's irritating sometimes. I've been on Civil Law, and I will see you later. Until later, my friends, I hope all's well. Cheers for now. Shit. Tony is now commenting from my own account. No. Holy shit. Tony's now commenting from my own account. Oh, Lord. Can I time myself out? Oh, my. Okay. I've been on Civil Law. Tell my friends. Cheers. Oh, Lord.